Hey guys, welcome back to another informative episode of the Global Business Leader series on the Chamber Guy. Kyrgyzstan is a largely mountainous country in Central Asia, bordered by China, Kazakhstan, Tajikistan, and Uzbekistan. Having a rich history dating back to the 8th century, the predominantly young population of slightly over 6 million people in Kyrgyzstan are proud of their country's rich traditions and culture. Being an open and democratic country with an economy that is built on agriculture, trade, and services, Kyrgyzstan has undergone complex social, economic, and political changes over the years since its independence in 1991. The civil society sector in Kyrgyzstan is one of the strongest in Central Asia, engaging with the government through numerous consultative public councils. The Chamber of Commerce and Industry of the Kyrgyz Republic is affiliated with the International Arbitration Court. To find out more about this affiliation and the role played by the International Arbitration Court, we have with us today Ms. Saltanat Imanova, the chairman of the Supervisory Board of the International Arbitration Court in affiliation with the Chamber of Commerce and Industry of the Kyrgyz Republic. Ms. Saltanat Imanova, thank you for joining us.
Thank you, Michael. Thank you for the great opportunity to introduce the IDR, Alternative Dispute Resolution System of my country, Kyrgyzstan, to the auditorium. And it is a great pleasure for me. So at first, to start with my practical activities, it started more than 20 years ago. And that was very interesting time when I was lucky to join the team of professional lawyers in Kyrgyzstan who was eager to establish alternative dispute resolution mechanisms in our country and to perceive the wonderful practice of the worldwide IDR system and introduce it to Kyrgyzstan. And I believe it was successful, and I am happy to be the member of this family up to date. And in 2002, I started to work for the International Court of Arbitration in affiliation with the Chamber of Commerce and Industry of the Kyrgyz Republic. I started as an executive secretary because that was the very beginning, and we started to get acquainted with these institutional arbitration mechanisms from the very beginning. So we were lucky to adopt in 2022 the law on arbitration, which was completely perceived the principal norms of the UNCITRAL model law. UNCITRAL, it is the United Nations Commission on International Trade Law, which is famous with its promotion of the international standards of commerce, trade, and investment involvement, and to create favorable conditions for business environment all over the world. And that norms were perceived by our arbitration law, and we successfully adopted it and started arbitration activity in Kyrgyzstan successfully. Moreover, the main law of our country, the Constitution of the Kyrgyz Republic, contained the special norm which allows to establish arbitration courts in Kyrgyz Republic. And that is why I believe we established the whole infrastructure and the mechanisms for the successful development of IDR system in Kyrgyzstan, including arbitration as well. So as for returning to my practical activity, for about 10 years, I worked for arbitration institution in Kyrgyzstan from the position of the executive secretary, and then I was appointed as the executive director of that organization. And also in 2007, I started my practical activity as an arbitrator. I was elected as an arbitrator and was included into the list of arbitrators of our arbitration institution by the Supervisory Board, which is the governing body of the Arbitration Court of Kyrgyzstan. And since that time, up to date, I considered more than 80 disputes cases as the chairman of the tribunal and a co-arbitrator. And also I was lucky to participate in 2 ad hoc arbitrations with participation of foreign parties. So there are differences between ad hoc arbitration and the institutional arbitration. The institution which was established in 2002 in Kyrgyzstan, that was institutional arbitration, and it is familiar all over the world as a body which is established for rendering services for the resolution of disputes by means different mechanisms. Mediation, arbitration, conciliation, etc., tools very popular all over the world in the resolution of disputes. Then in 2008, I joined one interesting project, investment project realized in Kyrgyzstan by Kazakh foreign investors. That was gold mining projects. And that was very helpful for me from practical point of view, because it was very important for me to understand how the business realizes its activities and which stages of projects shall be realized on this way. And also I would like to emphasize that the arbitration and the business, they are 2 close parts, because the arbitration is the key of business. I always used to say that arbitration is the key and creator of business, because it serves for interests of business to solve their problems, to solve their disputes, and to continue their activity without any barriers in the future. And now I've been working as a director of the gold mining company, Chara-Zav. This is the company with British foreign investments, which is operating the gold deposit in the south of Kyrgyz Republic in Chakal district. And at the same time, I was elected in 2022 the chairman of the Supervisory Board of the International Arbitration Court in affiliation with the Chamber of Commerce and Industry of Kyrgyzstan. And it is a great honor for me to combine both these positions, because, as I mentioned, arbitration and business are close. They're like brothers, I believe. And that is why I'm very happy that we have more than 20 years of the arbitration institution in our country.
Right. Thanks for that. That's actually a very, very impressive record that you have. Looking at it from the point of the general public, I'm still trying to wrap my head around how the International Arbitration Court in the Kyrgyz Republic works. What exactly is the role that it plays? Maybe you can just highlight a few points on the exact role that the IAC plays in the Kyrgyz Republic.
Sure. Today, I can specify with my pleasure that our arbitration court is an independent body that provides the prompt and high-quality resolution of economic disputes in the business environment through independent professional arbitrators. How it works? We have a supervisory board. This is the governing body of arbitration institution, and this body elects the chairman of the board and form the list of arbitrators electing professionals all over the world and include them into the list of arbitrators. And those arbitrators will consider disputes and are considering disputes when business parties turn to our arbitration courts for services on the dispute resolution. So a supervisory board also approves all internal documents of the court, including the regulations of the arbitration court, the arbitration rules, extradited rules, the list of arbitrators. We also have the list of mediators, and establishes the procedure for calculating the arbitration fees, the rates of that fees, and other expenses. So, generally saying, the board exercises leadership and control for the activities of the arbitration institution. So, the organization of work, including the arrangement of arbitration proceedings, is provided by the court management, introducing by the chairman of the arbitration court, Mr. Shamaral, my chief, who are the reputable and famous lawyer in Kyrgyzstan for many years. And also we have two deputy chairmen in the court, one for arbitration and another one for mediation services. And also we have a secretariat consisting of 3 or 5 people, and all of them are professional lawyers speaking different languages, and they provide professional services for parties when arranging the arbitration proceedings. So nowadays, the arbitrators of the court have considered more than 1,500 cases, and about 30 cases are now in progress. These figures undoubtedly evidence the stable growing of business confidence to the court. And this is also due to the fact that awards rendered by the arbitrators are executed voluntarily. And in case if the losing party refuses to execute the arbitration award voluntarily, it can be enforced by means of the getting the writ of execution in the court of general jurisdiction, because Kyrgyzstan joined in 1995 to the New York Convention on the forced execution of the foreign arbitral awards, which allow Kyrgyzstan Arbitration Court to provide for the execution of the rendered arbitral decisions, awards all over the world in more than 170 countries. And it is one of the main advantage of the arbitration, I believe.
Right.
So, and to gain the trust of foreign investors, foreign business circles in Kyrgyzstan, we have included practicing arbitrators from other countries in our list of arbitrators. And today we have 386 arbitrators in our list from 30 countries. And that countries include Kazakhstan, Ukraine, Uzbekistan, United States of America, France, Russian Federation, the Netherlands, Belarus, Turkey, India, Austria, Romania, Lithuania, Estonia, and other countries. So foreign countries doing business in Kyrgyzstan, often in their contracts, in the section dispute resolution, write down the arbitration clause to solve all their disputes from their contracts in the arbitration court of Kyrgyzstan. So, and if we look at the geography of the parties in the dispute over the more than 20 years of the existence of our institution, our court considered 86 claims in relation to foreign companies and entrepreneurs from 22 different countries, with participation of parties from Kazakhstan, Tajikistan, Uzbekistan, Turkey, Great Britain, and Russian Federation. And there was always cases involving parties from Bulgaria, Austria, Germany, Cyprus, Israel, United Arabian Emirates, United States of America, Cuba, South Korea, and Hong Kong. So the geography is quite expansive. We are proud of this, and we are ready to continue, and we believe and trust that this geography will be spread from year to year. So, and also I would like to emphasize that since 2018, our arbitration institution introduced the mediation services by adopting the law on mediation, so which allows our institution to provide professional services to resolve disputes by means of mediations as well. So today we have in our institution the list of mediators, which includes 18 qualified specialists. They are from Germany, Russia, Kazakhstan, Belarus, Ukraine, Pakistan, Estonia, and Uzbekistan. And there is no doubt that the widespread use of the practice of mediation along with arbitration will significantly decrease the burden of the state courts, and that will provide more options for business to solve their disputes using mediation as well. So, and also our institution since the very beginning has been providing the wide explanatory and information work among local business and foreign business on advantages and effectiveness of alternative dispute resolution by means of mediation, by means of arbitration. And these progressive principles permanently supported by the government structures. And now I can tell that we have progressive legislation for the further development of alternative dispute resolution in our country.
Thank you. Now, just to backtrack a little bit, you were mentioning earlier, and also we understand that you also hold a senior position in the subsidiaries of Charat Gold Holdings Limited in the Kyrgyz Republic. Now, how do you balance between these two roles?
Yeah, first of all, a few words on my current employer. This is Charat Gold Holdings Limited. It is the foreign company whose shares quoted on the alternative investment market. And it is a gold mining company which was founded in 2007. The initial goal was to explore and develop a gold deposits all over the world. And Charat now has two high quality development assets, one in the Kyrgyz Republic. This is the Charat Gold project in the south of Kyrgyzstan, the Tulkubash and Kızıltaş oxide and sulfide deposits. And another was located in Armenia. This is Kapan mine, and it was acquired by Charat Group in 2019. And it is producing copper and zinc concentrate from the underground mine since 2003. So now Charat has more than 1,000 employees located principally in Armenia and part in the Kyrgyz Republic. And today both companies of Charat Group have been implementing large-scale investment projects in both Kyrgyzstan and Armenia. So I see from my practical experience that arbitration and business, they are closely connected, as disputes may arise on each state of activity. For example, in gold mining companies, it is permanently conflicts may arise during the activity, whether it is a designing process or it is a construction process or this the production activity. So on each state, conflicts may arise. And that is why it is very important for business to have access to the prompt, fast mechanism for resolution their disputes in order further without any barriers to continue its practical activity. So Charat consistently applies best international legal, environmental, and social standards to all its operations. And that is why I appreciate the Charat Group of companies includes arbitration clauses in all contracts concluded, whether in Kyrgyzstan or with local companies or with foreign contractors as well. So today, the major foreign investors in Kyrgyzstan concerned about the instability, about the inconsistency of the legislation of Kyrgyzstan in terms of protecting the rights of business of foreign investors. Investors and traders are also concerned that if their rights and interests are violated, it is necessary to address to the state courts of the Kyrgyz Republic. But from the international experience, we see that foreign investors prefer to use the alternative dispute resolution mechanisms. In particular, they used to solve their disputes in reputable and famous arbitration and mediation institutions like Arbitration Institute of the Stockholm Chamber of Commerce, International Center for Investment Dispute Resolution, ICSID in the United States of America, London Court of International Arbitration, International Court of the International Chamber of Commerce, etc., which makes it possible to determine the fate of investments and secure their compensation. And I believe that addressing to our arbitration institution probably in future will increase their confidence to the services of the arbitration court in Kyrgyzstan, and the foreign investor will believe to our institution and will address to our court to solve their disputes with foreign investors, with the government, with the and other parties of the dispute.
Okay, and now usually an arbitration function is established under the Chamber of Commerce, but in Kyrgyzstan, it is an independent institution. Can you explain why that is? And what role does the Chamber of Commerce and Industry of the Kyrgyz Republic play towards the International Arbitration Court?
When founding arbitration court, we set the task to create the institution that is completely independent as possible from the influence of the founders, influence of the government or any state bodies. Thus, the establishment of institute in the form of a public foundation made it possible to achieve this goal. In order to exclude any influence on the activities of the court, founders, people who founded the International Arbitration Court, they have waived their rights as the founders, transferring the authority to manage the institution to the Supervisory Board, which is the highest management body of the ICA. Thus, the court is not subordinate to and doesn't report on its activities to the founders. Neither founders nor the members of the Supervisory Board are entitled to receive any income from the arbitration court activities. And now the International Court of Arbitration is a non-commercial legal entity that doesn't aim to make a profit. At the same time, today it is a self-sustainable organization that doesn't receive money from the state, and it doesn't depend from the state budget. The title International Arbitration Court contains the expression in affiliation with the Chamber of Commerce and Industry. It means that the court is not subordinate and accountable to the Chamber of Commerce. The Chamber acted as one of the co-founders of the arbitration institution, and like all other founders, it also waived its rights as a founder. Therefore, for the International Arbitration Court, the Chamber of Commerce and Industry is not a higher body. Arbitration Court of Kyrgyzstan is a completely independent organization reporting only to the Supervisory Board. At the same time, in most countries, arbitration institutions used to be established precisely at the Chamber of Commerce and Industry. And it is clear to foreign investors, to foreign traders and business entities all over the world. That is why the arbitration court in Kyrgyzstan referred to the Chamber of Commerce and Industry in order to be familiar to business circles, that it is non-state arbitration, it is alternative dispute resolution mechanisms. That is why we use in our title the reference to the Chamber of Commerce and Industry.
Thank you very much for that. Now, Is there any obligation for a member of the Chamber of Commerce and Industry of the Kyrgyz Republic to use the International Arbitration Court if there is any dispute? Are there any other options?
The Chamber of Commerce and Industry of the Kyrgyz Republic, it is one of the structures working with Kyrgyz commercial and non-commercial enterprises and organizations, individual entrepreneurs, members of the Chamber of Commerce and Industry of Kyrgyzstan, small, medium-sized and large-scale enterprises and companies, as well as leading business associations. The number of members of the Chamber of Commerce and Industry today are currently about 1,200 or more. The Chamber is a non-government organization and it carries out its activity in order to promote the development of the economy of the Kyrgyz Republic, its integration into the world economic system, the formation of modern infrastructure for market relations, the creation of favorable conditions for foreign economic activity, promotion of the development of exports of goods and services, all-round expansion trade, economic, scientific, and technical relations of the Kyrgyz Republic with other countries. It has functioned in accordance with its own law, the law on the Chamber of Commerce and Industry of the Kyrgyz Republic. And the current legislation of our country doesn't have any imperative obligations for the members of the Chambers of Commerce and Industry of the Kyrgyz Republic to solve their disputes in the arbitration court. It is definitely the parties' will, the parties' free willingness, and the so-called autonomy of parties to use either arbitration or mediation or litigation, and to choose by their own will the place where they prefer to solve their disputes. And the main conditions for parties to come to the arbitration court, to CCA, is the arbitration agreement or arbitration clause in the contract. Alternatively, the party may use arbitration in some cases provided under the law on arbitration.
Right. Now, one final question before we actually end this part. How does the International Arbitration Court differ from other dispute resolution institutions, especially with regard to mediation or litigation?
First of all, I would like to emphasize and let's start with the fact that the arbitration court is not a state court. This is, along with mediation, an alternative to the state courts, a court where the parties come up on their own choice per mutual agreement. The arbitral tribunal can only resolve disputes arising from civil legal relations. Most often these disputes arising in the business environment, the so-called commercial disputes. At the same time, in our court, for example, disputes over the division of property between spouses or disputes arising from contractual relations between individuals can be solved as well. And the category of disputes that cannot be accepted by the arbitration court is defined by the law. This is the disputes on bankruptcy, divorce procedure, labor disputes, etc., etc. The arbitrators are elected by the disputing parties themselves, and this is another advantage which is not allowed in the state court. In some circumstances, arbitrators may be appointed by the chairman of the arbitration court. Another advantage of the arbitral tribunal is that the award is issued and it is final and binding. So, comparing to the state court, where we have three instances, appealing. In arbitration court, we have only one instance, and then where the award is rendered only one time, and it is obligatory for this.
Great. Thank you so much for that. We have come to the end of this segment of the interview. When we come back, we will find out about some of the cases solved by the International Arbitration Court with the participation of Ms. Saltanat Imanova's company, and also coming up, her take on what the future holds for businesses as we head into the third quarter of 2023. Stay with us.